Hi, this is Amish.aggarwala. I'm an advocate practicing in Delhi, and today I'll talk about another very important aspect of criminal law, which is highlighted by the very recent judgment of the Honorable Supreme Court of India, which is Parminder Kaur versus State of Punjab, which was delivered just yesterday, that is on the 28th of July 2020. Now, what happened in the judgment was that the accused person was a woman who was charged with sections 366A and 506 of the Indian Penal Code, which are procuration of a minor girl, as well as section 506, which is criminal intimidation. Now, what had happened was the incident is of 1996. The trial court convicted the accused person in 1999. The High Court of Punjab and Haryana upheld the conviction in the year 2009, and finally in the year 2020 the Supreme Court said we will have none of this and set aside the conviction and acquitted the accused appellant woman. Now, what had happened was the allegation was that this girl was enticed, was kind of pushed into a room which had the accused person's tenant, a tenant boy who was apparently some rich tenant boy, according to the allegation, and the accused person forced the girl to have intercourse with the boy. And when the girl cried, it is only at that point of time that the other people and the witnesses intervened and the girl was able to escape. And on another occasion, the accused woman told the little girl that if she tells anybody, then she will have, there will be consequences. So therefore criminal intimidation was also invoked. Now, at the stage of trial, the court did not really look into the defense produced by the accused person and went on to go and convict. And in fact, rather than even relying upon a strong prosecution case, the trial court just kept looking at what the defense said wrong and went ahead and convicted the accused person. The High Court also went and agreed with the trial court's verdict. The trial court said that malicious prosecution of sexual abuses involving minors at the instance of third parties was improbable. The trial court also said that there was no reason to disbelieve the prosecutrix, that is the minor girl, and her father. The accused was sentenced to 3 years of imprisonment. The High Court said that the defense put forth by the accused person was an afterthought. Now, the Supreme Court came with 5 points to acquit the person. And under 5 headings, the Supreme Court passed this judgment. The 5 headings were sweeping generalizations and superficial analysis, shoddy investigation and prosecution, gross misappreciation of conflicting testimonies, failure to refute the Section 313 statement, and the charge of criminal intimidation was also not dealt with properly. Interestingly, the woman, the accused person, put forth her own story in her statement under Section 313 of the Criminal Procedure Code, where the courts have on several occasions held that Section 313 is very, very crucial. Everything which has come against the accused person must be put to that accused person so that the person can give an explanation as to what his version, his or her version of the true events is. Now, in this 313 statement given by the accused person, she said that she was actually raped by a particular man whose and against whom she filed her rape complaint. And after a few months, that person's employee, his daughter, is the one who had filed this case. And the biggest clincher for the court was that there was no effort made by the police to trace this so-called boy whom this accused person had allegedly procured the minor girl for. And on the basis of the inconsistency in the prosecution statement, the complete disregard by the trial court and the High Court of the Section 313 statement of the accused person, as well as the fact that the prosecution case itself was very, very weak, the Supreme Court acquitted the person. Now, this brings me back to this point that I have mentioned on several other occasions, and for people who have not seen other of my videos, I have said it on several occasions, and it is a very, very fundamental tenet of criminal law practice in India, that if you are accused of an offense, even if you are innocent, and especially if you are innocent, you must produce your defense not just under Section 313 CRPC, but also produce your own witnesses. enter the witness box under section 315 of the CRPC and give to the best of your knowledge the entire uh, length and the breadth of what transpired and how this case came to be. If you don't do it, you will suffer the consequences. This woman, she did put up a decent defense. She could have done better. I don't have the details with me, but I can only imagine that if she had other witnesses who could perhaps testify as to the fact that she was raped, she could testify as to the fact that this person was in cohorts with the father of the girl. This could have led more credibility and could have perhaps led to an acquittal at the trial court stage itself. And she got justice almost 20 years later. But again, a valuable reminder for all of us and a valuable lesson for all of us that we can take away. When you are accused of an offense, always produce your witnesses. But apart from that, at the very beginning itself, try to collect the evidence as soon as possible. If the evidence is not in your control, you invoke the powers of the police as well as the courts under the various provisions of law which are there. One of the strongest ones is section 91 of the Criminal Procedure Code. There are also civil remedies. You can do all of these things to kind of get material in your favor so that you can be sure of an acquittal. And even at the stage of grant of bail, for the consideration of bail, people take things lightly. You need to remember, try to collect as much evidence as possible, as quickly as possible. And in some situations, it is even more important because there are things like phone call records, social media details, which are of a very, very, transient nature. They will go soon. And so if you think 3 years or 4 years down the line, you will have that data, that even your memory will be fresh. That's not going to happen. Again, for the people who want to read this judgment, perhaps the case of Parminder Kaur versus State of Punjab, which was delivered by the Honorable Supreme Court on the 28th of July 2020. That's all for today. If you like this video, please go ahead and press that like button and subscribe to the channel, because I do keep putting out a lot of these videos to share with you what's going on in the law in India. That's it. Thank you.